Good afternoon, everyone. Welcome to our program. My name is Jeff Tenenbaum. I'm the chair of the nonprofit organizations practice here at the Venable Law Firm. Thank you for joining us today for our program entitled The New D.C. Nonprofit Corporation Act Takes Effect on January 1st, 2012, Everything You Need to Know to Comply. Glad you could join us for this program, which frankly we put together fairly last minute. I think only sent out the initial promotion less than a couple weeks ago. So close to the holidays, we're very gratified to see such a great crowd, over 100 people here in D.C. and about 150 on the telephone elsewhere in D.C. and around the country. We have a very interesting program for you here today. We have a lot of information we're going to jam into about an hour and a half, so bear with us as we move fairly quickly. As you probably know, this is part of our monthly seminar and webinar series that we've been doing through Venable's nonprofit organizations practice, although this is our second one we're doing this month. I see a number of you for the second time already in December, so we're glad to see you. For those of you who have not participated before, we do these free monthly seminars and webinars from 12 to 2 p.m. Eastern, once a month or twice a month if needed. A complimentary lunch here at Venable's D.C. offices from 12 to 12:30, and then the seminar and webinar from 12:30 to 2 o'clock. Also, as for those of you who heard in the room when we got started, these seminars are all recorded, so they are archived and available on our website along with the PowerPoint presentations for you to listen to or share with colleagues after the fact. A few logistical items before I turn it over to my colleagues. For those of you in the room, you have a bound booklet with your handouts that contain the PowerPoint presentation from today, along with an article that my colleagues and I wrote on the new D.C. Nonprofit Corporation Act. Those of you on the phone received a confirmation email that included the PowerPoint presentation. After the fact, tomorrow, everyone, both in here and on the phone, will receive a follow-up email thanking you for your participation and including a link both to the presentation materials, the PowerPoints, and the article, as well as a link to the recording that you can feel free to share with your colleagues. And as always, all of our nonprofit legal articles and PowerPoint presentations are always available on our website and searchable by topic area at venable.com/nonprofits/publications. And all of our recordings of our monthly seminars are available at venable.com/nonprofits/recordings. Finally, in terms of questions and answers, we do encourage you, as we do in most of our programs, to ask questions throughout the program. No need to hold them to the end. For those of you here in the room, raise your hand, and George Constantine, our moderator, will call on you. Just be patient. Sometimes if we're midstream in the middle of a thought, we may wait a bit to take the question, but do feel free to pose questions throughout, and our speakers will repeat the questions for those of you on the phones. You'll be able to hear them. For those of you who are on the telephone, we don't have a way for you to verbally ask questions, but utilize the chat feature on the webinar, and you'll be able to pose questions that way. George is monitoring the laptop at the front of the room where all those questions will come in, and he will pose those to our other speakers during the course of the program at the appropriate times. Finally, we do already have 3 programs in the works for next year. If you want to mark your calendars, 2 of the dates are confirmed, and one is it's going to be between one of 2 dates. On January 26th, we have a program called The Next Generation of Nonprofit Executive Compensation, Providing a Competitive Advantage for Your Nonprofit Organization. This is kind of a nonprofit executive comp part 2. We did a program earlier this year on the topic. This is going to take it to a whole new level. I think it's going to be a very interesting and important program for all different categories of exempt organizations, C3s, C6s, C4s, and the like. In February, on either February 22nd or 23rd, we're going to be doing a program, exact title to be determined, but it will be regarding international activities of nonprofit organizations. And on March 21st, we're going to be doing a program on employee privacy issues for nonprofits. All should be very diverse and interesting programs. Our speakers here today are 3 key colleagues in our nonprofit organizations practice. To my immediate right is George Constantine. George and I have been working here the longest, over 10 years, I think, together. We both got our starts at ASAE, at the American Society of Association Executives. I was there first, and George came there after I left and became ASAE's first in-house counsel. And we've both been working here at Venable ever since in the nonprofit organizations practice. George has been a terrific leader on our team and in our firm, and a key part of a very key part of our nonprofit organizations practice. To his right is Janice Ryan, and to Janice's right is Crystalline Losen. Janice and Crystalline are extremely talented associates in our group. Work day in and day out on nonprofit governance issues and tax exemption issues and contracts and everything else under the sun that nonprofit lawyers have to deal with. Are extremely familiar with the D.C. Nonprofit Corporation Act, old version, new version, and are going to be have quite a lot of information and insights to share with you here today. So with that, I'm going to turn it over to George to get us started. George?
Great. Thanks a lot, Jeff. Good afternoon, everyone. Morning, afternoon, everyone on the phone. As Jeff pointed out, our hope is to cover a rather broad section of topics here regarding the new D.C. Nonprofit Corporation Law. We want to make sure we get your questions answered when they come and when you have them, if they're relevant to the topic. As he said, given the number of slides we have and the amount of material we want to cover, we may defer occasionally to the end, and hopefully we'll have some time at the end as well. Just to give you a little overview of what we're going to do today. First, I'm going to figure out how this works. There we go. I'm sorry. I'm on the wrong slide here. Well, as I figure this out, I'll tell you about my overview, as Jeff figures it out. First off, if you are incorporated as a nonprofit corporation in the District of Columbia, this applies to you. It's a new law that took effect or was enacted over the course of a number of months last year into this year until it was finalized and made effective as of January 1, 2012. It does not apply to organizations that are doing business here and registered to do business here in D.C. as a foreign corporation, but that are incorporated elsewhere. Many of you may be familiar with organizations that are incorporated in Delaware, New York, or Illinois, for instance, but yet your home is here. Thanks a lot. In that instance, you are subject to the laws of the state of your incorporation. You may be registered to do business as a foreign corporation here, but you are, in terms of your internal governance, it will be the laws of your state of incorporation that control. Great, it's working. What we're going to do today is talk about the way kind of follow through the way the statute is structured and talk about the different activities that your organizations do that may be implicated by the statute. The way it's structured, there'll be first a discussion of the general provisions. You'll see how it's structured. There's kind of a set of provisions that apply to all corporations or all entities that are either incorporated or established as partnerships or other forms of entity in the District of Columbia. And then we'll go into some of the specific nonprofit provisions, first dealing with board and officers, then dealing with membership organizations, and then specific transactions like amendments to your articles and bylaws and mergers, dissolution, et cetera. And then we'll hit on a few tax provisions at the end there. Like I said, a lot to cover, and we got some great experts here. My role will be largely to be a moderator and maybe chime in from here and there, but you'll hear mostly from Janice and Crystalline as we go forward. So specifically, what's different or what's new about the new statute? For those of you who have been incorporated in the District of Columbia, you've dealt with a statute that we've dealt with a lot in counseling all of our clients on. We've become comfortable with it. But one thing we've noticed early on is that it's got a lot of holes. There's not a lot of areas that are not covered by the statute that we have to kind of make some judgment calls on as to whether what the rules of the road say as to this or that type of structure. This statute, which is based almost entirely on the model nonprofit corporation law, has a lot more kind of teeth to it, has a lot more details filled into it. There are some differences which we'll go over here. One thing to keep in mind is the new law includes a lot of opportunity for an organization to have its articles of incorporation or its bylaws say how you are governed and essentially trump the default provisions that are in the new law, so that you're not held to these default provisions, but when your bylaws or your articles are silent on those provisions, then the default would come into play. Finally, there's a tremendous final recognition of the ability to use electronic communications as part of what you do in your day-to-day business, and it's very welcome. I would say the way it addresses it, the new statute, the model nonprofit corporation law as well, is not immediately intuitive, but once you start to get the hang of what they're getting at, you can see it's tremendously flexible in terms of allowing for things like electronic notice, electronic balloting, electronic records, et cetera. In addition, there are a couple of new forms of governance that are touched on in the new law, which we won't go into much detail here, but things like member-governed corporations, for instance, are specifically addressed here. As I said, it's applicable on January 1, 2012. One point I would also add before going on to the next slide is the way the Model Nonprofit Corporation Acts work is they have commentary as part of their publication. When this statute was enacted, it was enacted in a way so that it was clear that the commentary that's part of the Model Act is considered legislative history for this law. So it's great. We actually have something close to regulations to point to in the event of some confusion as to what this or that provision means. Okay. In the general provisions section, yes, sir.
Where can you find the commentary? Is it online too?
You have to buy the Model Nonprofit Corporation Law. That's the 2008 edition. That's the latest one that the ABA has approved. And the question was, where can you find the Model Act and the commentary to it? So going over to the general provisions section of the statute, as I said before, and we'll talk a little bit in the next slide as well, the basic structure of the new act is there's a hub which talks about specific definitions and specific issues that apply to all organizations that are based in the District of Columbia and somehow incorporated or otherwise formed there, and then spokes that come out, and each different spoke is a different type of organization. We're Chapter 4. Our spoke is a nonprofit corporation spoke. So when it comes to more detailed issues regarding how to operate a nonprofit corporation, you'll look to that chapter. But the basic coverage is in the general provisions section. The general provisions section includes items on incorporation, registered agent, which for years the district would call these annual reports, even though you filed them once every 2 years. The reporting that you have to do with the district, your record-keeping requirements, and then we'll finally hit on issues related to those of you who may be old act corporations. We will get to what those are. So where can it be found? If you're interested, like Crystal and I each have a copy of the book here. It's Title 29. It's also online at this website that's referenced on the slide here. Click on the View DC Code link. It's not the most intuitive of ways to navigate, but you can figure it out. As I said, we've got Chapter 1, which is general provisions, which after I finish with this slide, I'll turn it over to Janice to talk more about. And then Chapter 4 is the one that applies to us. As you'll see, this was an incredible rewrite. It had a lot to do with not just nonprofit corporations, but business corporations generally, professional corporations, et cetera, all the different types of entities you can imagine are subject to new rules now.
As George mentioned, there are a number of important general definitions in this first chapter of Title 29. I think that as you read through Chapter 4 pertaining to nonprofit corporations, if you see certain terms that you may not know what they are they defined terms, it's always useful to go back to Chapter 1 to see whether they are in fact defined terms. There are many of them. But for our purposes, I think the ones to focus on are the ones that really broadly authorize electronic communication. There's a new definition for record. There's a new definition for sign or to sign. And essentially they are designed, although strangely worded, I've provided the exact language there, they're designed to broadly authorize electronic records and electronic signatures. And this should facilitate communication by email, whether that be notice or ballots or all of the things that nonprofit corporations do to communicate with their members, for example, or just in general with their board or among their board. These definitions are broadly based on the Uniform Electronic Transactions Act, which are in turn based on the federal e-signatures law, e-sign, electronic signatures, and Global and National Commerce Act. So it's designed to rely on the law that's previously existing over the past decade or so to facilitate electronic commerce. There are a number of provisions that facilitate incorporation in the district to make it a simpler process. This may be useful for some of you who are interested in incorporating affiliated entities or perhaps a related foundation. Incorporation now only requires one individual to serve as incorporator. Previously, you needed 3 people. A notary is not necessary. Those incorporators do not need to have their signatures in front of a notary. And the articles of incorporation generally require less detail. You have to provide your name and your registered agent information, and you must indicate whether the corporation will have members. However, it's no longer necessary to specify in the articles whether those members will have voting rights. You can now handle matters related to member voting rights in the bylaws. You may, but you do not need to list the initial board of directors. Previously, the initial board of directors had to be included in the articles of incorporation. If the initial board is not listed, incorporators may hold the initial organizing meeting to elect the directors and to adopt bylaws. Something that we think is pretty great as nonprofit corporation lawyers is that corporations can now restate their articles of incorporation. This is pretty common. Many other jurisdictions have allowed restatement for quite a while. The district did not previously have a provision allowing for restatement of a nonprofit corporation's articles. So this means that organizations that have adopted amendments to their articles over the years have had to keep their original articles and then the amendments that were filed piecemeal in a big document together, and it was kind of a puzzle to determine, okay, what do our current articles look like? Now you can put together in one single restated articles of incorporation all of the amendments that have occurred over the years and file that with the district as an official version of your articles of incorporation.
And for those of you on the phone, I understand there's a problem with the slides advancing. We're on to slide number 8 now. And if you have your handouts handy, you can page along with that, and we'll try to get the fix so you can see it on the screen as well.
So the registered agent provision is another area where the new act provides some flexibility. And this is the one slide that we'll be talking about that does apply to foreign nonprofits and nonprofits incorporated in the District of Columbia, because both need to have a registered agent. So to start with, a registered office is no longer necessary. The previous act had provided that you needed a registered office in the District of Columbia and a registered agent with the exact same business address. So that's no longer the case, but you do still need a registered agent. And there are 2 types of registered agents in the new Nonprofit Corporation Act. The first is the commercial registered agent, and this is a company like CSC that does this professionally, and they can file one, you select your registered agent, and then they can file if they have a name change or some sort of other administrative matter, and it'll apply to all the companies that have used them as the registered agent. You can also have a non-commercial registered agent, and this is a business or a person with a DC street address. It doesn't have to be a District of Columbia resident. And also an important change is that a change of registered agent no longer requires certification of the approval of the change by the board or by the members. So that's something that the organization can do internally and just file a form with the District of Columbia saying that we change our registered agent.
Question?
This is about the venue of the registered agent. So, for example, if it's a foreign corporation with activities in the district, as we are, we have CT Corp in DC, we have CT Corp in some other states, and we have the other states, CT Corp handle our DC registration.
The question is, if you're a foreign corporation registered to do business here in the district, do the new registered agent provisions give an opportunity, if I'm paraphrasing this right, for you to just use a CT Corp based in some jurisdiction other than the District of Columbia or CSC or whatever the registered agent provider may be?
I believe that the commercial registered agent would still need to have a DC address, so practically it would probably still be a commercial registered agent from the District of Columbia.
Yeah.
I hope that answers your question. The non-commercial registered agent, previously the Act required that the registered agent be an individual who's a D.C. resident who lives here. You could now have an individual who has a street address in D.C. but for some reason is not a D.C. resident, and that individual could be your non-commercial registered agent. Any other question on that slide? Okay. So another change is with the biennial reports, the 2-year reports. There's a new filing deadline. It's a little bit later now. It's April 1st. Previously, the filing deadline for nonprofits had been January 15th. So this will still be a 2-year report. It's due now on April 1st of the year after you incorporate in the District of Columbia. And it's still a 2-year process, but this harmonizes the filing requirements for corporations, for-profit corporations, and nonprofits. Now they're all due on April 1st. And we, as recently as this morning, I checked the website. It still looks like the forms haven't been updated yet. They still say January 15th. So if yours is coming up January 15th, 2012, you might want to still be early. But once the forms are changed and the Act really takes effect and DCRA has updated everything, it'll now be April 1st every 2 years.
Is that expected to occur after January 1?
I spoke with DCRA a couple of weeks ago, and they still hadn't written regulations or really updated their forms. So I'm assuming after it takes effect, they'll start that process, but you might want to give them a little bit of time. But officially, it does take effect January 1st. Okay, and then record-keeping requirements.
This is on slide number 10. Sorry, I didn't mean to interrupt.
Yep. So this is one area where your responsibilities are expanded a little bit instead of being more flexible. There are more records that now you have to keep and more records that you have to keep at your principal office. These are things that you're probably keeping anyway, but now it's specifically stated in the statute that it's a requirement. But the records can be kept in digital form. As we said, the definition allows for electronic copies. It just has to be able to be perceived and recorded in a perceivable form. So that would include, Word documents, emails, et cetera. And directors and members have expanded inspection rights for these records, and we'll talk about those provisions in the directors and members section. So the next slide, it says corporate record keeping at the top, and these are the specific records that you have to keep now. Permanent records, so these have to be kept in perpetuity. The minutes of all meetings of the board, members, and any designated body. We'll talk about designated bodies and what those are a little bit later. Records of all actions taken without a meeting, so all ballot voting, all unanimous consents, they'll all have to be kept. Records of all actions taken by a committee of the board or a designated body. Again, these are probably things that you're keeping anyway, but just to make sure if you're not, you have to start doing that January 1st. And then there are a few additional records that must be kept. Appropriate accounting records. This isn't really defined too much more broadly, but you'll want to be keeping whatever audited statements you have. Also, a copy of the corporation's members, and there are specific timing requirements of when this list has to be created, and you need to have it be alphabetized with a list of the names and the addresses and showing the number of votes that each member had.
For example, our bylaws allow ad hoc committees, but they don't have to go to any kind of the authority to act on behalf of the board.
The question has to do on the record-keeping front. If committee records, when it's referred to as records that need to be kept by the corporation, whether that refers to just committees of the board or also to the advisory committees, which we'll get to that difference, which is a little more clear in this version than the last statute, but I'm not sure what that means as to the record-keeping front.
I'm pretty sure that it specifies just committees of the board. I'll verify and take a look at the commentary and get back to you, but I'm pretty sure it's records of the board, right? You'd have a lot of records.
Not perpetuity.
Right.
With the accounting records, does that include monthly financials that go to the board or just annual audited statements?
Question has to do now with how specific financial records or accounting records are required under the statute. Some organizations will send monthly financials to their board, for instance, and also audited financials once a year. I don't know that the statute specifies a difference between those two. But.
It doesn't. Definitely the audited statements should be. If you keep those with your board minutes, for example, then maybe that would be covered,
right.
But at least the yearlies.
Yeah, I may be a little conservative here, but I would err on the side of all, board correspondence that's not otherwise, privileged or protected, is likely to be something that's part of those records.
And I would just add that you're probably going to want to look to IRS requirements for how long you need to keep your financial records as a more authoritative statement of the kinds of accounting records that you should be keeping.
And then the next slide is the records that must be kept at the principal office of the corporation, and those are your articles and your bylaws, minutes and records that have to be kept permanently. You have to keep the past 3 years of those records at the principal office. All communications that go to members within the past 3 years, and those include the financial statements that were furnished to the members, and a list of the names and business addresses of the current officers and directors, and finally the most recent report filed with the district. Previously, it was just your list of members that you needed to keep at the principal office, so this is greatly expanded. Although, again, you're probably already keeping some of these at your principal office. Yes, ma'am?
So when I send the CEO report to the board, it sort of gives an operational update. That's the communication that I now have to keep for 3 years?
The communications with the members. So are you looking under the fourth bullet?
Yeah.
Those are with members of the corporation, so it doesn't say to the board. Yes?
So records have to be maintained at the corporation's principal office. What do you do if they're electronic records, as you talked about earlier, and they're stored on some kind of cloud server off-site?
You'd want to make sure that those would be accessible in your principal office. So if somebody came to your principal office and wanted to inspect them with
the question was about electronic records, what to do about that. Just to repeat for the people on the phone. Go ahead.
So you'd want to make sure if you have a computer at your principal office that could access the server where your records are stored.
So somebody walks into the main office, and a person in the main office has to be able to access all these records.
Right.
No matter where it's stored.
Right. Yes?
This is sort of to anticipate the discussion on members later on, but also in this context, when we're talking about members throughout the statute or throughout the discussion, we're talking about members who have voting rights.
Correct. Who elect directors or have the right to vote on fundamental issues.
The question about members' rights and access to records is we're talking about members with voting rights, just to kind of reiterate the question.
Okay.
And later on, you'll talk about how you can make that clear in your bylaws.
Exactly.
Who a member is and what the rights are.
Right. We'll be covering a lot of the membership provisions a little bit later, and we have a ton of slides, so we're going to go ahead and move on, but if we don't answer your question about records later in the presentation, we'll answer it at the end.
Okay. This isn't advancing, so just go ahead. We're on slide
We're now on to the
13.
Old Act Corporation.
Slide 13. Okay. I don't know if this applies to any of you in the room, but there's a old act that in our parlance is an act that was in effect until, was it 1962? If you were incorporated before then, it was a very small nonprofit corporation act that was bare bones as bare bones could be. If you were incorporated under that old act, and then at the time what was called the new act came along, you had to opt in to be covered by the new act, or else you were still covered by the old act, which was a bit of a netherworld. It gave you some more flexibility because there wasn't a lot of lines drawn, but a lot of organizations took that opportunity to be part of what was then the new act and made that affirmative opt-in. But not all have, and there are still more than a few out there that are incorporated under the old act. Well, under the new act, what we're talking about today, that law makes very clear that old act corporations that are doing business in the district will essentially be phased into the new law. Basically, the way it works is within 2 years of the enactment of, within 2 years of the effective date of the statute, so December 31, 2013 will be the last day of the second year, you would have an obligation to file a notice with the District of Columbia that you are an old act corporation, or else you're not able to assert later that you're not subject to this new law. However, if you desire to do business in the District of Columbia, you do have to opt in to the new act. You essentially have to file articles of incorporation and be subject to the provisions of the law. There's been some dispute or back and forth among commentators on this provision, but it's clear when you look at the legislative history that that was the intent, to finally get rid of old act corporations. And there was a pointing to in the legislative history of what other states have done in this regard, and the idea that one can continue to grandfather in under the now old act is not something that can really obtain here, particularly if you want to do business in the District of Columbia. So now we're going to move on to, it is working. I'm sure this is mostly user error, by the way, so I apologize. Anyway, we're going to move on now to the board and officer provisions. We're going, from the hub to the spoke, to the nonprofit corporation spoke, and we're going to move pretty quickly. The topics we're going to talk about, and this is largely going to be Janice going through these, are board meetings, terms for directors, committees. We talked a little bit about that already, board committee versus advisory committee. There's this concept in the statute now of a designated body, which is very interesting for a lot of you who may have a House of Delegates type structure, those types of things. This is a new option for you. What officers are required, that's a little different. There's some very specific discussion of board member standards of conduct, which had always been left to common law in the past, but now there's very specific rules on that. We'll hit liability and indemnification provisions and the emergency powers of the organization as well.
So under the new act, there's a new default quorum for board meetings. The default quorum is now a majority of directors in office before a meeting begins. A different quorum may be established by the articles or bylaws, provided it's not lower than the minimum quorum, which is now 1/3 of the directors in office or 2 directors, whichever is greater. Previously, the default quorum provisions were keyed to the number of directors fixed in an organization's articles or bylaws. This new default quorum provision, it facilitates achieving a quorum, particularly if your organization might have a vacancy on the board. Now we're looking at the number of directors in office before a meeting begins. That's how we measure a quorum. Previously, meetings of the board were to be held upon such notice as may be prescribed in the organization's bylaws or by resolution of the board. Now we have some specific provisions in the statute about notice. Regular meetings, the default provision provides that regular meetings must be held with notice unless otherwise provided in your articles or bylaws. And you may provide a single notice of all regularly scheduled meetings for the year at the beginning of the year so that you don't have to give notice of each regularly scheduled meeting individually.
Is the quorum just for a meeting of the full membership or for like board of directors or executive?
Question has to do with the quorum. We're talking only about the board and directors section now. So
correct. So all of these provisions that we're talking about right now apply to the board of directors. Special meetings must be preceded by at least 2 days' notice unless the articles or bylaws provide for a longer or shorter period. The notice does not need to describe the purpose of the special meeting unless otherwise provided in your articles or bylaws. The articles or bylaws may now authorize oral notice of board meetings. That was not something that was previously provided under the statute. The basic rule for director terms has been maintained. Director terms may be specified in the articles or bylaws, and if not specified, the term of a director is 1 year. However, there's a new maximum term, and we've already received a question about the issue of the maximum term and its application. The term of a director may not exceed 5 years, except for directors who are appointed by persons that are not members, or directors who are designated in a manner other than by election or appointment. So, for example, this would permit an officer to serve as an ex officio director for so long as that individual holds that particular office. There is no restriction on the number of consecutive terms that a director may serve in the statute. You may provide for a limitation in your articles or bylaws if you choose. The question that we received previously was whether this applies, this maximum term limit applies to non-membership corporations. And I think we've taken a close look at the statutory language and have also looked at the commentary in the Model Act while we were up here. It is a little ambiguous, but the language, the commentary in the Model Act does seem to suggest that the election by members, that the term limit is keyed to directors who are elected by members. We'll be happy to take a closer look at that for you.
All right. And just a point on one of the questions that was raised by Chad is it's very clear here that consecutive terms are allowed. There's not a term limit provision in the statute. So renewal terms, for instance, are not prohibited by the statute.
As far as committees go, there's a similar structure as in the previous act. There are two types of committees. There are board committees and there are advisory committees. Board committees may consist of one or more directors. So you now can have a committee of one. Previously, at least two directors were required to have a board committee. Board approval is required for two things: creation of a board committee and appointment of directors to the board committee. The required approval threshold is the greater of a majority of all directors in office or the number of directors required by the articles or bylaws to take action. This isn't, in fact, a great departure from the current law. However, we have received a number of questions about this provision already from our clients, and so we wanted to point out this statute clearly states that board approval is required for appointment of directors to board committees. Board committees may exercise the power of the board to the extent specified by the board or in the articles or bylaws. Board committees may not, however, authorize distributions, approve or propose to members actions that are required to be approved by members, fill vacancies on the board or any board committee, or adopt, amend, or repeal bylaws. The corporation may create or authorize the creation of one or more advisory committees. This is a lot more flexible. There's no particular method by which the statute says you can create advisory committees. Advisory committees are not board committees, and they may not exercise any powers of the board, and that their members need not be directors.
And it's just to point something out there, it seems to me a bit of a gray area as to what is the power of the board. I mean, there's some obvious things that a board can do that are in the statute, but we've talked about whether a nominating committee, for instance, necessarily has some power of the board. And, I mean, I would argue not. That depending on its structure, it could, but not just by virtue of being a nominating committee. But that's the sort of thing to consider as you go about looking at your documents to revise and get consistent with this statute is, how are we going to word this to make sure that we're, minimizing any risk to, being in conflict with the statute. Sorry to interrupt.
The new act establishes a new concept called a designated body. Some, but less than all, of the powers, authority, or functions of the board may be vested by the articles of incorporation in a designated body. Members of a designated body shall have the rights, duties, and obligations of directors to the extent that board powers, authority, or functions are vested in the designated body, and the directors are relieved from their liabilities with respect to those powers, authority, and functions. Essentially, this allows you to create a separate group of individuals who will stand in the shoes of the board of directors with regard to whatever director powers or authorities they are given. And the board no longer will have responsibility or liability for those powers granted to the designated body. If you want to create a designated body, it must be done through the articles. So George mentioned earlier in the conversation that this might be useful for membership organizations that have a House of Delegates style governance model in which members elect a delegate to a House of Delegates. The House of Delegates collectively have certain governance responsibilities which might otherwise in a traditional corporation be vested in the board of directors. This designated body concept allows for that House of Delegates body to have board powers consistent with the statute. Another way that this might be used is for corporations who want to have non-directors participate in committees that have board powers. So otherwise, Otherwise, only directors may be part of board committees. If you have a committee and it's entirely composed of directors, the statute is clear that that committee is a board committee. If you have a committee that has board authority or authority to exercise board powers, and it includes non-directors, the only way you can have that is if it's authorized as a designated body through your articles of incorporation.
Just to follow up on George's point, regarding nominating committee, some organizations will have a parent nominate the board members of an affiliate, so the parent then becomes the designated body of the affiliate.
Some organizations may have a parent organization nominate or name the directors of an affiliate. That does not put them in a designated body position. I mean, the statute specifically recognizes that you could have another entity name your directors, and it doesn't list that as a power of the board.
That's not it. So the parent is not a designated body of an affiliate?
No, not in that situation. A parent would not be a designated body of an affiliate. One question on just to keep fairness to the chat people before we move quickly. The question was, if you've got back to the committee appointment process, can the board designate to the executive committee or other committee with power of the board the appointment authority? And I think, well,
that might be possible. I would have to look more closely at the language. I know that it specifically says that the committee shall be established by resolution of the board, but there isn't a restriction that I can recall of specifically that would prevent the board from delegating that duty to the executive committee.
Yeah, I think the executive committee probably could do it. Okay, right here, question.
For organizations that are not membership organizations,
Mm-hmm.
often their board committees, such as finance or fundraising, have non-board members. Is that now not okay?
The question is, if you're not a membership organization, you will have situations where many of you here are non-membership organizations. You'll have situations where your committees are made up of people who are not directors. It's okay. It means that the committee is going to be an advisory committee as opposed to a committee of the board. If you want to give those committees certain powers of the board, you would designate them as a designated body in your articles of incorporation or bylaws to show that they do have that power. Is that right?
That's correct. This is always a tough thing for organizations. You know, what powers are powers of the board that can be only exercised by members of the board versus things that other people can do. This comes up all the time in terms of the division between the board's authority and sort of your staff management and what they can do, what has to be done by the board. There are always fine lines, but those are judgment calls that you have to make. A finance committee, for example, might be making some significant decisions on behalf of the board and have the authority perhaps to approve of changes to your portfolio or some things like that. You need to consider what authority does that committee have, and really does that rightfully belong to the board? And if it does belong to the board, then you're going to need to maybe take a close look at whether you want to restrict membership of those committees to directors only, or perhaps consider taking advantage of this designated body opportunity.
And the last point just on that front is a lot of committees that I'm familiar with, a lot of structures that boards work with, there's tremendous deference from the board to the committee in terms of what's recommended, but there's ultimately a vote or an approval by the board. And essentially, even though the board may always go along with what the committee's suggestion or almost always go along with what the committee's suggesting, ultimately the board has to stamp that and has to say, yes, we're doing that. And that's a big differentiating point, I think. It's whether the committee has that independent power to bind the organization or whether it's really just recommending the board approve something.
So do we have to change the way we are referring to these committees if they are going to be mixed and they serve exactly the way we just described?
The question is, do we have to change the way we're describing these committees? The term committee of the board is a term of art in the statute and in other statutes. I would, for just lack of confusion and trying to be as clear as possible, I would avoid that term if the committees can be made up of non-board members and we're not identifying them as an advisory committee. We're not identifying them as a designated body. Just because committee of the board has a term of art that suggests that they have a certain power that they don't. So you can call them anything else. I've talked to some clients already about this. Apparently the term advisory committee is offensive, suggests a lack of gravitas. I don't know. You can call them what you want. I would just avoid calling them something that they're not, which is a committee of the board. Okay.
One more question.
Oh, one more question?
But you could call them just a committee.
You could certainly just call them a committee. That's right. Okay.
Okay. We have a number of other slides, so I'm going to try to go through these very quickly. There's a lot of information here. I'll touch on it, and perhaps to the extent we need to, we can address questions a little bit later on. Under the new Act, there are 2 separate officers required. One must be an officer responsible for management, for example, a president or some other title that you wish to choose. One must be responsible for finances, for example, a treasurer or some other title you choose. They cannot be the same person. So the president and the treasurer have to be 2 different people. One officer must be assigned the duties of a secretary, and either one of those individuals can hold the office of secretary or some other individual. Previously, the statute required a president, a secretary, and a treasurer, and the president and secretary positions could not be held by the same person. Under the new Act, we have now codified common law fiduciary duties of care and loyalty that apply to directors and officers. For directors, when discharging their duty as a director, they must act in good faith in a manner the director reasonably believes to be in the best interest of the corporation. This is the duty of loyalty. And with the care that a person in a like position would reasonably believe appropriate under similar circumstances. This is the duty of care. Officers have similar duties, although the duty of care is worded in a slightly different manner. So I've reproduced the standard here on this slide. George, you have a question?
Oh, yeah. The question is, can a treasurer also be a vice president? The statute doesn't prohibit that. It should be fine. I mean, they only address, the responsibilities of secretary and that 2 separate people be president and treasurer.
There are new provisions in the statute that specify directors and officers' duty to disclose material information. Directors have to disclose material information to the board or other members of a committee that are not already known to the board or to the committee that might be material to the director's discharge of his or her duties. An officer has a duty to inform superiors about information that's material to the officer's position. This essentially codifies what the basic rule is under the law of agency. Officers are also required to disclose to their superiors or another appropriate person any knowledge they have of actual or probable material violation of law or material breach of duty to the corporation that the officer believes has occurred or is likely to occur. There are new provisions on conflicted interest transactions and business opportunities, and these are concepts that are governed under the common law under what we would refer to as the duty of loyalty, but the statute provides for a process for directors to bring certain conflicts to the board and have them reviewed and approved by the corporation. So a conflicted interest transaction is a transaction between the corporation and any director, officer, or member who has an interest in the transaction. And the new statute says it shall not be void or voidable solely for that relationship, provided that the transaction at the time it is authorized is fair to the corporation, so we have a fairness element, or the material facts as to the relationship are disclosed and the transaction is approved in good faith by vote of the disinterested directors or by the members. Members don't have to be disinterested, members in general. For business opportunities, a director may avoid liability for taking for himself or herself a business opportunity in which the corporation might be interested, provided that the director first brings that opportunity to the corporation's attention and the transaction is approved in the manner that a conflicted interest transaction would be approved in, meaning that the material facts or relationship is disclosed and the transaction is approved by vote of the disinterested board. Loans to directors and officers continue to be prohibited. There are some carve-outs for various things like a loan secured by the principal residence of an officer or to pay relocation expenses of an officer, and advances for expenses related to indemnification. These are some specific situations where loans will be permitted. As a general rule, a director will not be liable to the corporation or its members unless the party asserting liability establishes that the director failed to meet the required standards of conduct for directors in discharging his or her duties. Thus, they breach their duty of loyalty or their duty of care. Notwithstanding this general rule, a director is not liable to the corporation or its members for any action taken or any failure to take any action as a director, except for a number of specified things, which would include intentional acts, intentional violation of criminal law, approval of unlawful distributions, or receipt of financial benefit to which they are not entitled. This limitation on liability for directors applies automatically to directors of charitable corporations. Directors of non-charitable corporations may only qualify for this limitation if it is specified in the corporation's articles of incorporation. Yes.
The question is this, the limitation of liability is a little different from the earlier version, and I think that the dividing out between charitable and non-charitable corporations in terms of its application is also new.
But you mean that we can expect a lower D&O?
I won't promise a lower D&O insurance rate. But it's an argument to take to your broker.
The important thing to know is that if you are not a charitable corporation, which means you are an organization, perhaps you're an exempt organization, other than a 501c3 organization, you need to look at your articles of incorporation and determine whether they need to be amended to provide for this particular limitation on liability, assuming that your organization would want to have that in there. The new Act retains provisions of current law related to volunteer immunity. This is not a change from current law, so I'm not going to go into depth about it. But essentially, if the corporation wants to ensure that its volunteers can take advantage of this immunity, the corporation must have liability insurance in specified minimum amounts. This doesn't relieve the corporation from liability, but the corporation is liable only to the extent of the applicable limit of the insurance coverage that it carries. The new Act has very detailed provisions governing when a corporation must, may, and may not indemnify a director or officer. These provisions require some close review and probably will be the area that your organization may need to focus on, most importantly in terms of amending your bylaws and articles to ensure that you are following the procedures that are required for indemnification that are now in the new statute. I'm not going to go into all the details, but I've provided in the slides a summary of when indemnification is mandatory and when it's prohibited. And I've covered the process generally in terms of permissible indemnification. In every instance, there is a two-step process. The corporation must authorize indemnification, and there must be a determination that the individual who is to be indemnified qualifies for indemnification.
I mean, the immediate need for all of us, obviously, is to address our bylaws and articles now. So my understanding of the statute is you can indemnify the minimum amount, and then at a later time, if you choose to, even on an individual basis, there's nothing prohibiting the board from indemnifying to the full extent permitted under the permissible standard. Is that correct? Is that a correct assessment of the statute?
Did you want to repeat?
So the question is, particularly looking at our bylaws and what we're going to include in our bylaws, are you getting at should the permissive provisions be in the bylaws, or can that be an independent determination made in the absence of them being in your bylaws?
Correct. If you don't include the permissive provisions in your bylaws, you can still choose, elect to later, even on an individual, the director gets to choose to indemnify at a later time following the statutory process.
Right. So any provisions in your bylaws that are inconsistent with the statute are essentially not of legal effect. So regardless, you are going to have to follow the procedures that are required by the statute. And in a couple slides here, I will just point out that The corporation may provide for broader indemnification than what is provided in the statute through a provision of its articles of incorporation. So you may want to consider whether you want to amend the articles to provide for the maximum extent of indemnification permitted by law, or you can narrow the protections of or you can narrow the indemnifications provisions that are provided by the statute through your articles or bylaws. So you do have flexibility to address your documents at a later time, but regardless, you're going to need to follow the procedural requirements for indemnification that are set forth in the statute.
But if you didn't put it in your articles of incorporation, let's say the mandatory, the maximum permitted, you could still indemnify.
The basic concept of indemnification is not any different. It's just a corporation may indemnify its directors and officers, and you may indemnify employees, and you may agree in your contracts with third-party vendors to indemnify them in connection with those acts. The statute doesn't limit the rights of the corporation to indemnify in that situation. There are a couple of areas where you may not indemnify a director or officer, so you need to follow those as provided in the statute. But that basic concept that the corporation has the ability to determine whether or how or when it will indemnify remains the same. Briefly, there's a provision here on emergency powers. If you want to, in your articles or bylaws, you may authorize the board to exercise emergency powers. It provides the board with some flexibility to hold meetings, change the principal office in the event of an emergency, which is essentially a situation where a quorum cannot be readily assembled because of some catastrophic event.
Okay, moving right along, we're going to switch over to the membership provisions. I know that some of you may not be membership organizations, and so this may not be as relevant, but I know a lot of you here looking at the registration list are. So the way Crystalline and I think I'll do some of these slides too, if I recall, are going to divide it up. We're going to talk about the statute's definition of members. We're going to talk about voting and meetings, how to work with a ballot, which is great. Now we've got a clear definition as to what we can do on the ballot front and electronic ballots. Delegates, we're going to talk a little more about the designated body issue. Talk about amendments and inspection of records rights for members, which kind of goes back to some of the records that Crystalline talked about earlier. And finally, we'll talk about financial statements.
Okay, so as we mentioned earlier, there's a new definition of what a member is in the new act. Previously, a member was defined by what rights you gave them in your articles or bylaws, and the new default is that a member is any person who has the right to select or elect directors or delegates or vote on any fundamental transaction. And fundamental transactions are defined in the statute, the ones that you can imagine, such as merger, dissolution, things of that nature, big events in the nonprofit's life. And so you can, in essence, have members that you call members that don't have the right to vote for directors or don't have the right to vote for these fundamental transactions. And in that case, they wouldn't be members as the statute refers to them. So some of these provisions for membership corporations, if you have, for example, associate members that receive your mailings and that you have communications with, but they don't have the right to vote either for directors or on fundamental transactions, you don't have to follow the requirements for members according to the statute. So under the new definition, just to get a survey, how many of you are membership corporations? How many of you have members with those rights? Okay, it's about half and half.
About half of the room.
Okay. So some new definitions. Delegates are referred to in the new statute. These are the people that are elected or appointed, the people who do elect or appoint a representative assembly for the election of directors or other members. So these are the people who are part of the designated body. And delegates are created by the articles or the bylaws according to the new statute, which is a little bit of a nuance on how the designated bodies are created, and I'll touch on that in just a minute. And the purpose, as Janice mentioned, is for large membership organizations to have another body that makes, for example, policy decisions or does something other than the board of directors, whatever powers that you give that designated body. So again, a designated body is a group or persons that have some but less than all powers of the board or powers of the members or both. You can give them either board powers, or you can give them the powers that are reserved to members, or they can do a little bit of either. And there's no really illumination on what some but less than all means. There's no exact definition of that. But if you gave them all the powers of the members, then they would be members. And if you gave them all the powers of the board, then they would be the board of directors. So I think that's what the some but less than all language is touching on. And again, if they're vested with board power, then they must be created in the articles and not the bylaws. So if you have a group that is, it's a designated body and it's made up of delegates, and they're exercising some powers of the members, say they're voting for directors, but they're also exercising some powers of the board, say they make some financial decisions or something like that, then that group has to be created in the articles. You can't create them in the bylaws, and that's the little nuance from the previous slide. Okay, so membership voting. We have some new membership voting provisions. The default is that each member has the right to vote on matters that are submitted to members. Previously, the language said that the members have the voting rights that are provided in the articles or the bylaws. So organizations with members that have the right to vote for directors or have the right to vote on fundamental transactions should look at which other rights that are granted to members by the statute. Look at the other fundamental transactions and make sure that you're okay with those people having those rights, because otherwise you'll want to limit it in your articles or bylaws. And voting for directors is by a plurality of votes cast instead of the majority, so greater than the numbers cast against it, but not necessarily 51%. So that's a little bit of a change. And also, cumulative voting is no longer permitted as a default unless you specify that cumulative voting is allowed. And there is a little bit of a grandfathered in clause that says if you didn't have it in your articles or bylaws, but you permitted cumulative voting before 2010 when this act, or before this act took effect, then those organizations are grandfathered in. But new organizations that do not have cumulative voting provisions can't allow cumulative voting if it's not in your articles or your bylaws. Okay, membership meetings. There's a new default quorum, and that's a majority of the votes entitled to be cast. This can be greater or lesser according to the articles or the bylaws, but that's a change from 1/10 of the votes, which was the previous quorum. So that's kind of a big jump. So if you don't have a quorum specified for your members in your articles or bylaws, it's now a majority of members, which could be difficult, although the electronic meetings provision that we'll talk about later does make it a little bit more flexible to have meetings. Again, the new act authorizes electronic meetings, and it says that it can be held via the internet or other electronic communications that permit members to read and hear the proceedings substantially concurrently with their occurrence, to vote on matters submitted, to pose questions, and to make comments. So I'm thinking of that some sort of online like chat feature where people can interact at the same time, but the law really allows you some flexibility to take account for communications that we can't even think of now, that maybe 10 or 11 years down the road allow people to meet electronically somehow. And there's also a new default for special meetings. Previously, it was 5% of the members. If you didn't say how many members were required to call a special meeting, it was 5%. The new default's a little higher, it's 10%, and there's also a new cap at 25% of members. So if your articles or bylaws say for a special meeting you need 50% of members, that's now in conflict with the new act. 25 is the highest amount that you can require. And again, as Janice mentioned, there's a ballot voting provision, which is really helpful. And it can allow action to be taken by electronic ballot. And you have to use the same quorum requirements and the same voting requirements that you would if there was an in-person meeting. And there's also some specific things that you need to include in that ballot. It needs to be in the form of a record, and that can be electronic. We're going back to the definition of what a record is in the main general provisions section. And it has to set forth the proposed action on the ballot, and it has to provide an opportunity for that person to vote for or against the candidate or to vote for or against the issue. Additionally, the solicitation that you send, the email that you send with the ballot or the cover letter has to state the number of responses that are needed for a quorum. It has to state the percentage of approvals needed for the action to pass or the director to be elected, and the time in which the ballot should be received. So everyone who wants to vote can file their ballot in a timely manner.
And just for those of you with membership corporations and our experience in dealing with them is there are a number of members who make sure you're adhering right to the letter of that law when it comes to votes and things like that. So it's real important to not get out of whack with what the statute requires and create a little minor firestorm among your membership because you forgot to have one of those little things disclosed. So it may seem like a almost administrative point, but it's very important.
Another change is to amendments to the articles and the bylaws. It's different according to if you're a membership corporation or you do not have members. To amend your articles in a membership corporation, the amendments now must be approved by the board and submitted to your members. There are a few exceptions to this. Administrative amendments, there are a few things that the board can amend the bylaws for that they don't need the approvals of the members, and those are specified in the statute. Also, members can propose and adopt amendments if they have 10% or more of the members entitled to vote, and you can change that number in your articles or bylaws. And additionally, if you have a designated body, certain amendments will have to be submitted to that designated body if you require that in your articles or bylaws. For a non-membership corporation, the board can adopt amendments if it's provided, unless it's provided that somebody else would do that in your articles. And they also must be approved by the designated body if your articles or your bylaws require that. Or there are a few little nuances. If somebody appoints a director, they're not elected by your directors, but they're appointed by somebody else, and you want to change that provision, the person who's allowed to appoint the director has to approve that amendment. And likewise, if there's a designated director, this person in your bylaws or your articles is named as a director. If you want to no longer include them and amend your articles to do that, that person has to approve that amendment as well.
One point, just to go back, as a chat question came up that I think we should probably clarify is, we're talking about member votes here and member balloting and all the great options that are there. You know, there's still the general rule, if you're a board of directors acting as a board, you've got to act at a meeting of the board or by unanimous written consent. And the meeting of the board can be one at which individuals can simultaneously hear one another. I don't think that's changed yet either. So there is no ability to take a ballot of board members that's less than unanimous and have that carry the day. So just a reminder, we're talking about member votes now, not board votes, but I wanted to make sure I pointed that out.
Thanks, George. Going back to the amendment section for bylaws, members can amend or repeal the corporation's bylaws unless it's specified differently in the articles or bylaws. And that's a new thing that you'll want to take a look at for your organization. And the board of either a membership or a non-membership corporation can amend and repeal the bylaws unless that's otherwise provided in your articles of incorporation or your bylaws. And in a membership corporation, there are still certain things that the members must approve for bylaw changes that the board can't do on their own, and that includes changing the rights of certain members, levying dues. That's something that you'll want to make sure that your members have a chance to take a look at if you're amending the bylaws to amend the dues. And relating to termination or suspension of members, if those provisions are changing, you need members to approve those changes. Okay, and now we're going to go back to the records provisions that we were talking about and the new and expanded membership inspection rights. The corporation, if you're having a meeting of the members, the corporation has to prepare notice, and that must include the address of each of the members and the number of votes that those members are allowed to have at that meeting. An inspection must be able to begin 2 days after the meeting notice. If a member wants to come in and see the list of who else is going to be there and how many votes they have, you have to allow that 2 days after the notice of the meeting. And the member must be allowed to copy that list upon written demand if they show proper and relevant purposes. And there is a different procedure if you want to have your corporation under this different procedure and not provide inspection rights. You can instead offer, upon proper purpose, you can offer a different provision for meeting the purposes that the member wants the list for. If you can come up with something else that will achieve those purposes without allowing them to copy the membership list, you can. That's probably not going to be used a whole lot, but we can advise if that's something that's relevant to your corporation. And then failure to make the list available does not affect the validity of corporate action. This is something that was in the previous statute, but we wanted to point out with expanded inspection rights, that doesn't mean that if you fail to make your list available, that the action that's taken at the later meeting is invalidated. It just means that the member still has the right to that inspection. And besides the membership list, there's also expanded rights for other documents. Upon written demand and 5 days' notice, the member can inspect the articles, the bylaws, the minutes of action, communication with members for the last 3 years, the list of directors and officers, and the most recent biennial report. And these are the things that are going to be in your corporate office. So if a member sends you written demand, sends you notice, within 5 days they can come in and inspect those documents. And a proper purpose, they have to state why they want to inspect these specific documents, the meeting minutes that are older than 3 years, the accounting records, and the membership list, which is touching on the earlier slide. And these rights can be abolished by the articles and the bylaws according to the new Nonprofit Act. And Janice and I spoke about this earlier. It looks like that might be a typo, but right now it definitely says that these rights can be changed or abolished in your articles or bylaws. So if you don't want members to have these inspection rights, you can amend your articles or bylaws, but it looks a little fishy right now, and it might be changed once people really take a look at it.
If you have members who aren't really members, is it advisable to specify that in bylaws saying that for purposes of the law, you are not considered members with rights and
right, or at least that these persons do not have the right to vote on fundamental transactions or elect or vote for directors, because that's what the definition is keyed towards.
The question is, if you've got individuals or entities that you call members but don't fit the definition of member here, should you specify something in the bylaws that makes clear that they're not members for purposes of the Act? So I'm just repeating the question.
Right. And if you're going ahead and amending other things, that would make it nice and clean. But if you already say in there that they don't have certain rights that the member definition is keyed towards, you may not want to do that clarification.
yeah, and you don't need to, just our bylaws, for example, specify what the rights and obligations of the members are, and so that they're not this definition. But someone looking at the weekly law might think, well, we have all these rights now. But if you go back to the bylaws and says, however, you don't have these rights X, Y, and Z, then it's clear that they're not law. Otherwise, you have to apply.
Right.
Right. Right. I think definiteness, or being expressed, is probably the best way to go if you can do it. It's a bit of a challenge to go to the members, and well, they're not approving the bylaws change, so it doesn't matter. Never mind.
Okay, back to the accounting records. And there's a separate section on the financial statements as opposed to inspection rights for other records. And these say that members can look at your latest financial statement with written demand, and that these financial statements have to be accompanied by the accountant's report if they're audited, or by the president's statement that the accounting records followed the generally acceptable accounting standards, or if he or she can't say that, they have to explain how they were prepared. So it might just be better to go ahead and follow the generally accepted accounting standards. And the nonprofit can impose a reasonable charge for copying these records. And it's important, because this is a separate section, this right of inspection cannot be abolished. So this one, the typo was not in there, and financial records, you can't restrict that right for members to inspect them in your articles or bylaws.
Okay, we're going to plow through the last part here. Oh, yeah, quick.
That's a quick question on the reasonable charge. When you say that the entity has to make the records available or provide, that can also be an electronic form?
The question is making it available or providing it to members. Can that be can that be an electronic form?
It didn't say specifically that it could be in an electronic form, but because the records themselves can be in an electronic form, it seems reasonable that offering the person some sort of way to perceive it, if it's on a disk or something like that, seems to be covered by the definition.
Yes, question right behind.
Yeah, I wanted to ask earlier. How do you define financial statements?
Question is, how do you find financial statements?
Audited statements?
I looked up, because it says accounting records. There's no definition of accounting records in either the general or the nonprofit statute. So I think, your audited, the typical ones that you would see is probably what's being contemplated, but unfortunately there's no more helpful expansion of that definition.
Well, do you suggest more than the audited statements?
If we were presented with a request, we would look more closely into that, see the nature of the request. My default would be, well, obviously audited and other information that's routinely prepared or provided to the board is likely to fit under that of a financial nature. But there's probably case law in other states having to do with just this sort of thing that we might analogize to if we had to. Okay, we're on to fundamental transactions, and we're at the point in time where we would like to have finished to open up for questions, so we're really going to plow through now. basically, we'll talk briefly about what the fundamental transaction section of the statute is all about, and then hit on some specific ones that are discussed here, amendments by third parties, domestication, charitable dissolution, and other transactions. As has been referenced in a few of these slides already, fundamental transactions are amendments to the articles of bylaws, mergers, membership exchange, sale of all or substantially all of your assets, something called domestication, which we'll talk about, conversion or dissolution. Without getting into too much of the specifics about amendments, generally we thought it would be interesting to point out that there's a provision that allows for specifically addresses situations where you have a third party that has some approval right over amending your documents, like your articles of incorporation or your bylaws. It allows for this. It says it can happen as long as there's a provision provided for in that particular document, or in the case of the bylaws, it could also be in the articles. What I've found is, having worked with a lot of organizations that have a national chapter relationship, that a lot of times you'll have a national that has that final say over whether this amendment is approved, a bylaws or articles of incorporation amendment. But they don't want to be members of the organization, so this is kind of expressly allowing for that sort of approval. It also would be helpful with affiliates as well.
The statute provides for a new type of fundamental transaction called domestication, and it permits a nonprofit corporation to transfer its jurisdiction of incorporation without having to create or merge into a different legal entity. You can only do this transaction if it is authorized under the laws of both the new and the old jurisdictions. There aren't that many jurisdictions that currently have adopted the most recent version of the Model Nonprofit Corporation Act. Probably about 3, I think Virginia, Massachusetts, maybe Pennsylvania. So this isn't going to be of widespread use quite yet, but as states begin to broadly update their nonprofit corporation acts, you may see more use of this procedure. Some of the potential benefits may be changing your state of incorporation without having to assign contracts to the new entity. If you're the same entity, then you don't have to go through that assignment process. And it may also be possible to maintain your existing exempt status with the IRS. Ordinarily, if you were to undergo a merger, go into a new entity, you would have to apply to the IRS for recognition of exempt status for that new entity.
Yeah, and that's an interesting point because we get asked that very frequently. Can we change our state of incorporation, and what does that mean? And usually, if you change your state of incorporation as a tax-exempt entity, that's a transaction that requires a new application to the IRS, either Form 1023 if you're a C3 or Form 1024 for most other sections of the code. We're not saying for sure this sort of process obviates the need for that because the IRS hasn't told us yet, and they're notoriously slow in terms of catching up with what the statutes are. But the language of the statute itself is very encouraging on that front, and that it says specifically that the organization will be the same entity. Quick question? The question is, would it be used by an organization that's staying in the same jurisdiction but undergoing a major reorganization? My hunch on that is that even with a major reorganization, a restatement of the Articles of Incorporation would be all you would need. You wouldn't take the domestication step. It really is only for the separate states, but maybe you have a different thought.
No, correct. You only use this if you want to change your jurisdiction of incorporation. There we go. Charitable dissolution, you now have to provide a statement to the Attorney General that you intend to dissolve before you file your articles of dissolution with DCRA or with the mayor. And the reason for that is probably protection of the charitable assets, just so the Attorney General can know what's going on and they can make sure that the assets aren't squandered. But the statute does state that it should not delay or otherwise affect the dissolution process. So it's not like an approval of it, it's just notice with the Attorney General, and that's from the Model Act. Procedures for provisions for additional fundamental transactions are not significantly different, such as merger or sale of your assets. Membership approval thresholds and or requirements have changed slightly for some of those issues, and if you're going through those types of transactions, you're going to be looking closely at the statute anyhow. There's a new provision on, it restricts disposition of charitable assets when you're going through a sale of assets. It says property held in trust or otherwise dedicated to a charitable purpose may not be diverted from its purpose in a sale of assets unless the corporation obtains an appropriate court order to the extent required by and pursuant to the laws of the district on cypre or otherwise dealing with the non-diversion of charitable assets. So you would be looking to things like UPMIFA, the Uniform Prudent Management of Investments Funds Act. Yeah, those are the types of other provisions that you would be looking at, and that's incorporated in this statute. All right. There is a new a provision, an amendment to the provision of D.C. law that grants exemptions from the local franchise or income tax. Previously, local exemption was effective at the date of your application to the district for recognition. So this meant that if you weren't on the ball in getting your application into the district for local income tax exemption, you may have a period in which you are still liable for taxes, at least under the district law. Now, the provision, the effective date of your local exempt status is keyed to the effective date of your exempt status as determined by the IRS. As a general matter, this means that provided you are recognized or you apply for recognition of exempt status with the IRS in a timely manner, your exempt status will be effective to the date of your incorporation.
Both on the federal level and local.
However, it is important to know that you still must apply to the district to be exempt from local income taxes. That requirement has not changed.
All right, well, that wraps our discussion here on the slides. I know we have some questions that came through on the chat we haven't been able to get to. I'll give a couple of those right now, and hopefully we'll have some time to answer some of your questions as well here in the room. The first question came in was from a few slides back there, Chrislyn, but I think it was yours. Similar to the what constitutes financial statements question, what constitutes communications with members? The questioner said that, we send a weekly newsletter to our members. Is that the sort of thing that would be considered part of the records of the organization? And I'll say, unless you've got it, I'll give you my take first.
Yep.
But feel free to contradict me. But I think what we're getting at here is more fundamental communications having to do with, specific to the membership rights that the individuals have, things like notice of meetings or ballots and things having to do with election of directors and those sorts of things. I don't think news of the industry or those sorts of things is what was contemplated by the Act.
Right. I would think as well it's the things that you have to provide notice of and the more official statements. If you write back and forth with one individual member, I don't think that's contemplated by the statute either to have to be kept on record at your corporate office.
And we had a question about the quorum requirements for a board meeting. And this is a rather technical question that I don't know if it's part of the Act or not. But essentially, does the Act address whether the quorum is determined? I'm showing how I need my glasses here. Whether the quorum is determined at the outset of the meeting and whether it needs to be sustained for the duration of a board meeting.
Under the default provision, first of all, you can alter the default by your articles or bylaws, so you're going to want to look at what the provision of your bylaws states first and foremost. But under the default quorum, the quorum is determined. It's the number of directors in office before the meeting begins. So it is keyed to how many directors are in office before the start of the meeting.
And then does the quorum continue, does the meeting still consider to have a quorum even though people may have dropped off?
I would have to look more closely at that. George has the statute book out. I'm not sure that you can, I would assume that you can continue the meeting, based on my understanding of prior law, continue to the meeting even if you lack a quorum, but you would not be able to take any action at that meeting.
I think that's correct. Under 40624 is the quorum and voting requirement. It says a quorum, when a quorum is present when the vote is taken, the affirmative vote of the board is an action of the board. So it sounds like you need to maintain that quorum throughout the meeting to take action of the board.
Okay. And then the last question in the chat room here. Is for a non-member corporation, we have natural person directors who are in office by virtue of being a member of a religious congregation. Hence, Hence, the board of directors does not select these members. Okay, I think the question is, do we need a term limit? I think first off, yes, you can have directors be chosen in that way. That's not prohibited by the Act. It seems to be the type of selection that would not subject those people to the 5-year term limit. Is that your take?
My sense of the question is that if they qualify as directors based on some outside qualification that is provided in your articles or bylaws, and they meet those qualifications, then yes, they would not be subject to the maximum term limit because they are appointed by or elected other than by members or designated in a manner that would not subject them to that maximum term limit provision.
Okay. Any questions here in the room? Okay, I think we're right at our hour here, so, oh, I'm sorry. Yes, sir.
I know, for instance, in my association, we tend to favor, when we're going out for some sort of work, favor our members. We do an awful lot of contracting with those member organizations. Is all of those under a conflict of interest transaction?
I believe the answer is yes.
The question is, an organization that favors transactions with its members, could those be considered conflicted interest transactions? The issue then becomes whether they are, it's one of two things. Either they're fair or they are vetted through a conflict of interest disclosure and consideration process. The fair question is, kind of easy to say but hard to define in practice. I think it would, in many of those situations where you've got a transaction like that, you would not want to rest on the fair prong. You would want to go through the conflict of interest review. How many members total are we talking about? What's the pool of potential customers in these situations? I mean, over 1,500? But a small number that do services, right? I think an argument could be made if it was a large pool of members to say, by virtue of going out competitively among them, we are essentially establishing the fairness of it. But if it's a small pool where you're not really getting enough bids to establish the fairness of it, you may have to go through the conflict of interest procedure before agreeing to that transaction. Yes? Great question. Do the new rules alter the requirement for a conflict of interest policy by the board? We'll often call this a requirement, but it's what's strongly recommended by counsel, and it's also what's asked about on your Form 990. It's not a requirement to have the policy or enforce it, but it's strongly recommended by counsel, and IRS is asking this question. That hasn't changed. What you want to do is make sure your policy is not inconsistent with this. And my take on the statute is that the policies generally go farther or at least have a little more detail to how they're operated as opposed to what the statute says. Another question? Yes, ma'am.
Delegation authority to committees. You mentioned earlier that all the times that the board would say we're approve it, but what is the board delegating? Significant responsibility in specific committees. That is it. Is it not true or just off the record?
Well, the question is, what if a board delegates a lot of its authority to a committee? From the statute's perspective, if it's delegating authority and giving power to act to that committee, then that committee needs to be a committee of the board, and it needs to be constituted according to the way the statute says. Now, depend on good governance. I mean, depends on the size of the committee, the size of the board, and all those good things. I mean, I would not be one to say you can't delegate to a committee because it's bad governance, having seen some of these organizations with literally hundreds of board members, and you can't act as a board. You need to delegate to a committee in those situations. Yes?
I hate to go back to the very beginning, but I just want to get 100% clear as to who is excluded from the DC Nonprofit Act. You mentioned before Delaware Corps and foreign nonprofits, which we are. And I just want to be 100% clear as to whether it applies or not.
The question had to do with foreign corporations and the application of this act to an organization that may be incorporated elsewhere, like Delaware, and be based here and may be qualified to do business here. There are only a couple of very discrete provisions that apply to your organization that really affect you. Would be the registered agent stuff that we talked about, and the biannual report change. But there's a provision that's specifically in the statute that says nothing here will affect the governance or internal governance of an entity that's not incorporated in the state, in this district. Sorry. Okay. Well, if there are no other questions, I'd really like to thank you for your time and patience, both on the phone and here in person. We had a lot to go through, and hopefully it was a little illuminating. We'll be around for questions afterwards if you want to come up.